So in the case of auditing company, for example, there was a real case in the US when one of the companies, auditing companies, was indulged in this case, and so out of one, the famous Big Five, that company was bankrupted by the state. So, sir, is there any same implications in the European law? Like in USA, that company has to be shut down by the state.
So I have not fully understood the whole thing.
So actually,
So the company was the state.
the state closed that company
The state,
because it was
state?
indulged in the wrong auditing, willfully indulged in the wrong auditing.
The Enron case where Arthur Anderson had
Yeah,
to.
Enron.
Yeah. Yes, but I agree. Yes, that this Anderson was that right? Yes, but that company was ruthless. It was almost, it violated ruthlessness and deliberately and willfully all standards. And that is a different case. I was here referring only to simple negligence. If behavior is ruthless and willful, then these considerations do not apply. And this is quite interesting that in German law, even though it is very restrictive German tort law, if you have willful or ruthless violation of such norms, even if they lead only to pure economic loss, then the legal consequence is full damage compensation. And that is in line with economic considerations, because that is something different from pure negligence, simple negligence.
And so, in which country was the case to be filed? For example, the same case happened in India also, the Satyam case.
Yeah.
So, sir, if the company was of USA and the audit took place with the company in India and fraud also took place in India, so where will all the cases will be filed and whose rules will be to be followed? Indian judiciary or US judiciary?
Well, that depends. If you have an Indian company and if it is listed in the United States, let's say at the New York Stock Exchange, then this company is accepted at the New York Stock Exchange only under the condition that SEC law applies and that it exposes itself to the American system. So an affected would then have the choice either to move the case to an Indian court or to an American court. But if he wants it in an American court, that is then possible. If this company is only listed in Bombay, let's say, that is still called Bombay Stock Exchange, right? At Bombay Stock Exchange, then I don't think that the affected can go to an American court.
So, but the auditing company is of US based. So, in that case also.
No, I mean if you have an Indian company, purely 100% Indian company, which is stock listed, but only at Bombay Stock Exchange, then the situation is different.
Not to compensate pure economic losses
Yes.
is based on caloric criteria.
Based on
Caloric criteria, the efficiency criteria.
yes, that is yes. You can. That is a good observation. One can say that, of course, if one would always compensate pure economic losses, it is good for the victims. But it is not good for the society as a whole, because the society then experiences people who are taking too much caution, and that can be also very detrimental for the society. As we know, for instance, from cases of medical malpractice, that can be easily overdone. So, this overkill. You know, just to illustrate this for the case of medical malpractice, I have a friend who is a marathon. He is very sporty, and he runs marathon, 42 kilometers. And he once told me, he's also a professor and also specializes in law and economics in Germany. And he said that as a child, he had a problem with his foot, with one of his legs. And the blood circulation did not properly work in one of his legs. And his parents were desperate, and they went from one doctor to the other doctor, and all doctors said that the leg should be cut off, amputated. Otherwise, it would be too problematic. And so then his father found another doctor who said, well, we can try with medicine, with pills, but it is risky. The pills can have heavy side effects, and it is a method which is not fully tested and so on. So the father said, we want to save this leg of his boy, and he took the pills and fully recovered. And now is a marathon runner. Now, he told me that if we had this medical, this sharp liability for medical practice, then this doctor would probably not have done this, because the amputation of the leg, that was the established state-of-the-art practice of a doctor. So the doctor knows exactly when he amputates the leg, then this was the way most doctors would do it, and what the established best practice. And this one had tried another way and saved the life of the boy. But if you have too much liability, then you get this defensive, what we call defensive medicine, that medical doctors do what is generally approved, and where nobody can tell them this is, this was a fault or so. But if they try to do something and help something, perhaps take some risk, and then if you have the liability maze every time something goes wrong, then doctors will abstain from it, even though it is desirable from a social point of view. Yeah, well.
I mean, I think I had asked some similar form of question sometime back. I mean, the problem of tort law in a financial sector is extremely. I mean, we saw in the US crisis, there was a lot of bad behavior by investment banks, and people still feel that has not been that they've not been held accountable for that. It's very difficult to identify who the victims were and how to compensate them, and B, how which banks to go after and how to. I mean, is there an efficient outcome? Should the response here be that we should really shut down or limit investment banking in general, or is it that we identify like particular players and only sort of be involved?
Yeah, well, this leads to the more general question of how we should cope with the banking crisis. And, well, this is a very big issue. And we have now, in the European Union, we have new rules. Banks must have much more equity capital, and some of, I'm not an expert in banking, I have to admit, and finance, but of course I follow to some extent the literature, and one of the best people in Germany in this field, they say what we need is very simple rules for the banks, not this complex rule of these Basel rules, much simpler rules. And he proposes, Hilbrecht proposes that the banks should have an equity capital of at least 20%. Deutsche Bank, for instance, which is the biggest German bank, is now close to bankruptcy. And it made very risky investments with an equity capital of 3%. But it has a balance sheet that the total capital of Deutsche Bank is almost 2 trillion euros. That is as much as the total, about 10% less than the total public debts outstanding of the German state. So it's huge, and if this bank goes bankrupt, then you have this inflation effects and so on. So the banks are always, the big banks are in the position to blackmail the governments, because they say, well, you cannot let us go bust, because then the effects for the country will be too high, so you must rescue us.
The too big to fail problem.
Too big to fail, yes. But too big to fail meant during the financial crisis that the state subsidized these banks. But this is, I think, subsidize the bank and protects its owners. But this is not anymore the case. We had already several smaller banks going bankrupt, and they were then nationalized. The state became the owner of the bank, and that means at least that the old owners lose everything, and the management is also fully replaced. And I think that's in principle, a good solution to the problem.
So, an add-on to this question. So, when the US state followed the quantitative easing policy, so don't you think that it was not the net social loss, the 10 and 80 consideration? The net loss was supposed 100. So I think the US government has given 100, full 100, and not to the right people to be compensated, but only to that companies, the big firms. So do you think that it was the right compensation in terms of the compensation given to the people and the amount?
So who got the compensation? Can you?
Sir, actually they influxed the firms, the bonds they were having. They bought out all the bonds and they influxed money on those firms only. In except to that, what they could have done is that they could have compensated the amount lost during that time that we have calculated from the graph to the people who have invested in the wrong times. Suppose, let's say from 2007 to 2008.
Well, I don't know. I cannot answer that question. I can perhaps in the abstract say that if you have a financial institute, then the tendency is to protect the small investors, small savers, for instance, but not the big ones. So the small are fully protected. If a bank, for instance, goes bust, then everyone who has a bank account is protected up in Europe up to 125,000 euros, but not more. So if somebody buys millions of bank bonds, for instance, then he's not protected. At least that is the theory. Whether it works in practice is an open question, because we have now some banks might go bust. Now you have other banks then who bought the bonds of this bank. Now assume Deutsche Bank issues bonds and Dresdner Bank buys the bonds of Deutsche Bank and vice versa. Then, you know, this is a strategic method of creating linkages, you know, and guaranteeing that if one bank goes bust, all the other banks goes also bust. And we really do not fully know how this all clinches together. And therefore, because we do not exactly know, the Deutsche Bank will be rescued if it really goes bust. But where we have general agreement, I think, is that at least the owners should lose all their shares before the state comes in.
So could you throw some light on LLM applications and scope for law and economics for higher studies?
For
LLM applications for law and economics and higher studies in general.
Oh yeah. Well, a program which I can of course recommend, and I think Mr. Prasad was also part of that program, is the EMLE program in law and economics, European Master in Law and Economics. This is a unique program of 1 year, and you can apply for the program. They have even grants from the European Commission, which are very generous but also very competitive. And the interesting thing about this program is that the students move from one place to another place. So you can study in Hamburg, Rotterdam, Bologna, and some other places also. So most students go at least in one term to another university, and some even all 3 trimesters. So they go 4 months to Hamburg, 4 months they go to Bologna, and 4 months, let's say, to Warsaw. Or India is also a partner of that, the Indira Gandhi Institute in Mumbai. That I can recommend. There is now also a law and economics program at the University of Turin, which I know the people very well, but the program is quite new, so I cannot say anything about the program. But they have also a doctoral program there, which is quite good, and I teach from time to time in that program. And that is, but how good the law and the LLM program is, I don't know. And then there is also a law, as far as my knowledge goes, they establish now a law and economics program in Mannheim, in Germany. And in the United States, you can do an LLM rather than a master. But if you are interested in the law and economics, if you have become interested, and if you think of doing a master in this course on LLM, then the envelope program, I think, is the best recommendation I can give you.
What are the general sort of things that should be probably there in a SOP for a LLM sort of program? I mean, I've not really written one before, so if you have any pointers on writing a SOP for a master's application.
You know, to write a good master thesis, the most important thing is that you have a clear question. So when I look at my experience about reading master thesis, what is a good master thesis and what is a not so good master thesis, or what is a really bad master thesis, then, you know, the weakest master thesis have always been those, not those where the people did not know the stuff or did not, you know, work hard or so, but where they did not find a clear question, so that the whole text is just an addition of different contents, you know, an addition of contents which is unrelated to each other. So that is the most important thing for a master thesis, that you have a clear question. And then the second most important is that if you have the clear question, then you should use this clear question really as a razor, like Occam's razor. What is sometimes an overwhelming drive, not only for people who write a master thesis, but even those who write a PhD thesis, is they have read something very interesting and they think, you know, it is so interesting that I have to write it down, even though it does not fit into the question. So you must always be focused to your question. If you have a question, use the question as a razor and ask every sentence you write, has it anything to do with the question? If not, let it go, even if you think it is very important and so on. And then, of course, you should try to write in a style which is well readable. So some students make the mistake that they resort to a kind of specialist jargon, and you know, then I just had recently read a master thesis which was full of acronyms which I did not know, you know, KLT, PLO, not the PLO, but other PL, and so on. You know, I was not an expert on that, and few people are. A handful of people were perhaps expert in this field. So try to be understandable to somebody who is curious and willing to read it, but sometimes it becomes too technical. Then, of course, what is important is try to get the most important literature and understand the most important literature. But if you keep these things together, I think you write a good master thesis. Yeah, well, time is not fully over, but I think it is defendable if there are no more questions to end the session, or what, Mr. Chairman, what do you say?
No, I am not chairman, I am also participant. So I would like to say a few words. It is not a kind of concluding thing, but Professor Schaefer's thought, which he would like to share it with you. today is the last one, but there is also possibility 29th, if he wish, he can take. That is on zoning theory, but it is not yet undecided. So if he takes it, then I will be in, and if he allows, then I will be in. But it is not decided yet. At outset, from my heart, it is really very happy occasion on the campus at IIT Kanpur, having such a learned resource person and expert and knowledgeable, and always favor to India. That is really another thing. I think that he has kindly agreed and accepted to come all the way and then spending time with us. This is really, we are lucky, and we have to try to get as much as knowledge from him and then try to be in touch with him. Whatever manner you can contribute to our present society and future society, whatever the title of the course which we have mentioned, social, economic and technological challenges. I think you people should lead. That is needed, because it is a multi-group, lawyers, technologists, economists, managers. It's a really multidisciplinary group, and the subject is interdisciplinary. I got an opportunity to really be in the class. At times I also dozing, listening whatever the things which we get. But his expertise and his command in the subject really put the things, the concepts and its applications and its definitions through graphical and then narrating case studies, hypothetical, numerical and real world situations, the sharpest one, which it can really, we can fully understand. It is really, I am telling you, whatever little experience which I have on this subject, it is very difficult at this short time talking about the interrelationship between law and economics, standard versus the rules versus standards, and then the property rights like Post theorem, and then contracts like fully specified breach of contract, and then the liability rules, and then it's pure economic loss. All these things, it is if I need to do this, I need a semester, and that really kept in the mind that all of the different kinds of people are sitting in this classroom, and he tailored the delivery of the information, the knowledge, in such a manner everyone should be comfortable, and then everyone should be really benefited out of it, and it reflects when each and every session is over, when there is a discussion session, the manner in which you people are really raising the questions, and he is really giving a kind of appropriate kind of information. It is really amazing and worthwhile. I really thank Professor Schaefer to really giving us this opportunity. And at the same time, it is really, you are here, that's why we are doing this. If suppose you won't give us this opportunity, so we also won't get this. So it is, both parties are really needed to, in order to do a collective activity on this law and economics. We hope we together carry out further and then try to give some kind of contribution to the society and benefit to the people, while we are earning our degrees and our livelihood. So that is. But this is, as I said, this is not a kind of last one. We will have on 31st. But especially this is for Professor Schaefer. This is a few words. So whatever I know little, I have shared it with you. If there is anything missing, I think please excuse me for that.
So yeah, thank you very much. Thank you for inviting me. You know that I like to visit this country, and I'm glad that you have done so much here in India to promote law and economics, and what I can do to help others to promote this, I will do. And I have always had the highest appreciation for Indian academic scholars, and so it is always for me a pleasure and also rewarding to work with Indian students with you, and I'm grateful that I could be here. Thank you very much.
Thank you.
Yeah, if anyone want to just say few
Can I?
words, I think it is better to give opportunity.
My friends, let me say few things for myself and before coming to this course. I am now 40 now, and I have 9 juniors in my chamber in the High Court. And ordinarily, lawyer of this standing coming to a class is somehow you can understand. And again going to university, again going to class. But what I really felt interest here, one, the art of conversation and delivery, having wisdom. The pauses you have with a deeper thoughts, complicated thought, and how you make comprehensible. So that art which I have learned and produce it for the course. Second, frankly speaking, I have no idea about this field, law and economics particularly, because I was groomed in a very simple, ordinary law school. But later I grew with the judges and the top lawyers and all that, corporate problems, and there I have learned a lot. But there I have learned jurisprudence and the practical problem of the law, so I have to refer the judgments and the text which is available, and then I have to read the mind of a judge. So I have never learned the art to the economics part of it, rather than I have learned that grain theories and science and all these things in my personal capacity. So I must tell you that this is the thing which is required to be developed in India. Now I am 40 now, another 10-20 years are remaining. This is the hope which can be generated in new people like this, like that young man and that young girl, this young lawyer. So Mr. Prasad is correct. This is a middle-aged old man experience. Really benefit. Really. Those lawyers are really unfortunate who have not heard Mr. Professor Schaffer. This has come to the lawyers, some sort of a middle-aged group sort of a thing. So courts can be better interest. That is the area which I am missing. Everybody thinks of his own, like that LLM question came in and like that. So I was thinking of myself and my profession. So thank you for all wisdom, and I'm just pleased. No much more words to explain. Thank you.
Okay. See you again.